Good morning, and may it please the court. Joseph McCluskey appearing for Harry Coleman in this post-conviction matter out of Shelby County. I was just looking at my calendar on this one. I've been working on this case for over 10 years. Mr. Coleman is actually scheduled for release later this year. So that's how long this case has been going on. We are here on this post-conviction petition out of Shelby County. The judge denied his petition for post-conviction relief. We are asking the court to reverse that decision and remand the matter for a new trial. We've raised in our petition for post-conviction relief and on appeal that trial counsel failed to investigate, failed to conduct reasonable diligence in this matter. We submit actually that not only did we prove that at the post-conviction hearing, but that this court in the first appeal actually kind of tacitly already agreed with that by stating in the original motion for new trial that the trial counsel did not perform, or we were unable to show that there was due diligence in the motion for new trial in his attempts to look at mental health evidence. We kind of look at that and say, okay, the opposite of, if there's lack of due diligence, we can call that deficient performance. Lack of due diligence is deficient performance. We submit that that's a question of stare decisis, that it's already been decided by this court in the motion for new trial that counsel did not perform with sufficient performance, that was not reasonable diligence, and that performance was below the threshold, that he failed to investigate this, I'll be frank, kind of a complicated mental health issue. So we definitely are submitting that there was failure to investigate, that there was lack of reasonable diligence, and the court has already decided on that question. Furthermore, we would submit that a duty to investigate is a duty that a trial counsel has. There is case law that says, State v. Burns, I believe, that failure to investigate is deficient performance on its face. There's other case law that says that the failure to, we're not going to credit as a strategic choice failure to investigate. Lack of knowledge is not a strategic decision. What we have here in this situation is exactly that. Counsel said that there might be some mental health problems, but we're just not even going to look at it. Period. End of it. They did nothing.
Well, that's not exactly accurate, though, counsel, right? Because, I mean, the way I read the record, it was the trial counsel saw the client. Client said, I've, have seen Dr. Farmer. There may be some bipolar issues. Counsel spoke with the family. The family indicated that there weren't mental health issues. The defendant was able to communicate with counsel. The trial counsel at that point, relying upon his observations, relying upon the family, relying upon what the defendant was telling him, was making a call that it did not appear that a mental health defense was a viable defense. So it's not the same case, is it, that he just said there are mental health issues, I'm not going to do anything about it. I mean, there was some investigation at least.
I think that the investigation that existed was deficient, that he simply basically listened to the client. The client said, I don't have any mental health problems.
And the family.
And the family.
And the counsel's own observation.
And the counsel's own observation. We're not mental health diagnosers. We don't do that in our job. We specifically, if there's that question, we submit it to someone else for that. We're not supposed to do that. And in fact, if we are supposed to do that, counsel here missed some serious red flags. Number one, speaking with his attorney, Mr. Coleman told his attorney, yes, I've been diagnosed as bipolar disorder. I don't like taking my medicine. It doesn't help me. As an attorney who deals frequently with people with mental health problems, that's the biggest red flag that anyone can ever say. When someone says, I don't like taking my medicine because it doesn't help me, that tells me that they have deeper mental health problems and we need to look more closely at it, not that we need to ignore it. He also indicated that he doesn't always take his medicine.
The medicine was for severe depression, though, right?
It was.
So it's not medicine for bipolar disorder with paranoia.
Correct. But that's when we get into, when we say someone is taking medicine but it's not working and I don't always take my medicine, that tells us that what's happening isn't working. If you're taking your medicine the way you're supposed to, you're going to have a different result. It will be working. If someone says, I've been diagnosed with this thing and I'm taking my medicine, but the medicine's not helping me, That's a clue right there that the diagnosis and the medication are not the solution to the problem, that there's a different problem, in fact. Counsel failed to recognize that. I mean, I frequently talk to my clients, and when they tell me their medication's not working, I talk with a doctor to work on getting that fixed so we can have fixed medication issues. The mental health of our clients is incredibly important.
So if we were to spot you on deficient performance, and I'm not saying that we would, but let's assume that the court spots you on deficient performance, the brief doesn't really address prejudice. And your friend on the other side says that even if there were a medical condition, a mental health issue, that affected his ability to perceive a threat, that under the law, the threat still has to be objectively reasonable, meaning that he's not entitled to use deadly force in response to the actions here, even if he perceived that he was under imminent threat of death or serious bodily injury, if objectively that's not true. I think I don't know that that's what your friend on the other side says in its entirety,
Right.
but that's what I took from their brief.
And
In this case, excuse me. In this case, what proof is there that there was an objective imminent threat of death or serious bodily injury? Not just the defendant's perception, the petitioner's perception. I don't recall the trial record indicating that there was a deadly weapon that the victim was using. I don't recall that apparently there was a gentle shove between the victim and the petitioner's wife, but no other altercation there. Objectively speaking, what gave rise to the petitioner's use of deadly force as opposed to other type of non-deadly force in the self-defense context?
Sure. First off, I disagree. Whenever a man pushes a woman, I disagree with classifying that as a gentle
That's
shove.
fine, but I mean, if we're going to take our prior opinion as gospel on deficient performance, our prior opinion also characterizes it as a gentle push, not something that is going to give rise to death or serious bodily injury. So if we're going to take that opinion for one thing, I think we take it for everything. Sure. So what evidence is there then?
Right. So we're getting into, and again, I think that in the heat of the moment, when someone pushes your wife, I don't think anyone would ever classify that in the heat of the moment as a gentle push. I think objectively, someone at that moment would say, my wife just got pushed. I'm going to objectively have opinions about that.
We're all going to have opinions about that,
Right.
but we're talking about whether there's an imminent threat of death or serious bodily injury. I'm going to have opinions about that. You will too, and I think we'd be justified in having that.
Yeah.
Justified, though, in using deadly force is another question. And
Right,
that's what I'm getting to.
That's just one part of it. The other part of it is that Mr. Schwerin and I believe one of his sons, after the defendant pulled his gun, and this is disturbing, after the defendant pulled his gun, they continue to approach him. When someone has a gun trained on you, the normal response is to not approach the gun. When someone continues to approach after a weapon is pulled, that's a sign of aggression.
And isn't that when the petitioner put the gun in the victim's mouth, and then after that occurred, the victim backs off?
At some point, the victim backed off, but the victim continued to approach.
Sometime before the shooting, there was a retreat.
There was a retreat, and I think the retreat ended, and the victim...
How is there imminent threat of death or serious bodily injury?
So I think the victim had retreated and then ended the retreat and continued to go forward, is my understanding of the facts of the case. But that also...
He was unarmed.
Right. An unarmed man can still do damage.
I agree, but it's an important fact, right?
It is. It's absolutely an important fact. However, in unarmed, we allow self-defense even if the victim is unarmed.
We do, but it's also an important factor. And so, I mean, all things being equal, if the victim is armed, all right, then maybe the jury gets closer to finding that there's an imminent risk of death or serious bodily injury. He's unarmed, and so we're being forced to look at what other actions are occurring. And
Absolutely.
so the only other action occurring is that he happens to be advancing at some point?
Well, he's there with his son. There are two men, not just one. There's a group of people all around. There's a lot of commotion, a lot of yelling going on. Two people are approaching an armed man. The armed man was scared and fired when those two people continue to approach him. This also kind of ties into the testimony that we submit should have been presented from one of the witnesses, Mr. Plunk, who would have testified that he was there at the scene. He actually saw one of the victims swatting at the gun, kind of pushing it away. And I think if you're in a situation where you've got a gun and you're saying, hey, back off, we need to end this fight, and the people then are smacking at the gun saying that's not how this is going to go down, or giving that impression anyway, maybe not physically saying it, but demonstrating that through their actions, I think that also increases the objective view of the situation at the time when you've got people literally hitting the gun, saying, stop this, stop this. There's a physicality there. And again, what we have to look at is all of those circumstances taken with the mens rea elements, with what was happening with Mr. Coleman at the time, when he observes all of that, when he processes all of that, with knowing what he's got going on in his head that we know now, we didn't know then, but we know now, all of these misfirings that are happening, he's got all of this objective information that he interprets in a way that causes that reaction that he has. And that's what we're getting into. All of this feeds into each other. It all kind of goes together, if that makes sense.
I can't remember in the record. Did Mr. Coleman know the victim?
I don't believe they knew each other beforehand. I think that this was just kind of a one-off where they had never had any interactions. I'm not aware of any interactions.
So many of the witnesses that weren't called by trial counsel that could have testified about the victim's violent nature or whatever you call it, probably would have been excluded from testimony if Mr. Coleman didn't know the victim, because that was about prior incidents.
Right.
Correct?
I think that there, specifically with the Hornsbys, that he was unaware of that issue that the Hornsbys had, and I fully admit that he was unaware of that. That was knowledge that he didn't have at the time, and it wouldn't have all fed into how he was perceiving things. I think it just would have shown to the jury that it would have been a question of whether or not Mr. Schwerin would have been behaving consistent with that earlier
Well,
kind of
it would
behavior,
be
which
to
is
corroborate
problematic.
that the victim was the first aggressor.
Right.
I mean, and only for that.
Right, just for that purpose.
Going back to Mr. Plunk's testimony, at the time of trial, at the time he would have been called as a witness, was he able to remember the events?
So I'm not clear on that.
Okay, well, we need to be, right?
Right.
So he had a brain injury in between?
Well, so that's the record in this. So he said at the post-conviction hearing, he testified that he was available and ready and able to testify at the trial. Trial counsel said that there was that issue with the brain injuries. So I actually, reviewing it, I don't know, but I admit that if he had brain injuries and there was all of that going on, absolutely no competent attorney would have called that.
So did the post-conviction court address that issue?
I apologize. I don't specifically recall how well the post-conviction court kind of touched on the testimony of those witnesses, but I think that the post-conviction court did not specifically make a ruling on those three witnesses. So I think there was some description of the testimony. I think the post-conviction court may have said it was a tactical decision, but then did not give any kind of analysis at all.
So in other words, did the post-conviction court either expressly or perhaps implicitly credit the testimony of trial counsel? I mean, that finding of fact would resolve the issue.
Right. I expect that if we were to read and I apologize, I did not read the opinion yesterday, I'm sorry. I'm sure that there is some kind of tacit approval of trial counsel's, because again, I think he did say it was a tactical decision. The court did say that. But that is kind of a weird, and I fully admit, that one's kind of a weird factual thing, the way that those two testimonies didn't quite line up.
Sure.
So I don't know exactly, but obviously if we credit counsel's testimony, then there was not deficient performance on that.
Okay, fair enough.
And that's just the way that is. But I think there is an issue with the court not fully addressing it in its ruling. I believe I have discussed all of the main points I wanted to talk about today without getting myself any more confused than I need to be about any of this. If there are no further questions, I will defer to the state now. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the court, Davey Douglas, on behalf of the state. This court should affirm the judgment of the post-conviction court because counsel was not ineffective here. And turning first to the issue of the investigation into the petitioner's mental health, this issue has not previously been decided. The doctrine of stare decisis or res judicata or collateral estoppel does not compel the conclusion that counsel's performance was deficient. Whether a defendant, either through himself or herself or counsel, was diligent in obtaining evidence so as to raise a claim of newly discovered evidence that would warrant a new trial is wholly separate from whether counsel was deficient in deciding not to make further investigation into a particular pathway for a possible defense.
And that's in part at least because the Sixth Amendment lens imposes additional findings that have to be made. And so one finding is that the representation or the failure to investigate was so far below the threshold that we would expect an ordinary reasonable lawyer to perform that it amounted to deficient performance. And it also requires an examination of the strategic nature of not proceeding forward based upon the information that you have now. None of that would be considered at all in a reasonable diligence inquiry on the discovery of new evidence on a motion for new trial. Is that right?
You're exactly right. You're exactly right, Your Honor. And that's something this court pointed out too, as well, saying that the defendant was not diligent in obtaining this mental health evidence. It called trial counsel's decision not to further investigate strategic, which further emphasizes that these are two very separate inquiries. So this court is not bound by its prior opinion to then conclude that counsel was necessarily deficient here. And what we have in the post-conviction record really shows the opposite, that counsel here made a very thorough, very detailed, very reasonable investigation, and that was not deficient performance. He started by talking with the petitioner, who mentioned that he had seen a psychiatrist, but he sort of discounted the psychiatrist, saying that he didn't think he was really good, he didn't think it was helping, and so counsel then talked to the petitioner's friends and family. None of his friends, none of his family members gave any indication that he was suffering from a mental illness. From everything that trial counsel found, the petitioner had a good social network, he was a successful businessman, and he had strong relationships with his family. Counsel also testified that there was no indication that the petitioner was suicidal. The petitioner never told him that. The petitioner's wife never told him that. And so based on all of this information, counsel then made a reasonable decision that it wasn't necessary to further investigate the petitioner's mental health.
So let's say that I think the next step that your friend on the other side says should have been taken was that counsel should have interviewed Dr. Farmer. What does the post-conviction record reveal that Dr. Farmer would have told post-conviction or would have told trial counsel? What additional piece of information to the puzzle would Dr. Farmer have given him?
All he would have given him was that the petitioner suffered from major depressive disorder. And I say that noting that Dr. Farmer did not testify at the post-conviction hearing. This comes just from his affidavit that was submitted into evidence, which I believe comes from the direct appeal. But Dr. Farmer was very clear in his affidavit that he had never diagnosed the petitioner with bipolar disorder, and he was very clear that he would not have told counsel that the petitioner had bipolar disorder. And then counsel explained that had he talked to Dr. Farmer and just learned about the major depressive diagnosis, that would not have likely fueled further investigation. He didn't think that that would have helped bolster a self-defense claim, so he would not have gone further and requested, say, an evaluation of the petitioner.
There's a curious line in the court's direct appeal opinion where this court says that Dr. Farmer would have confirmed that the petitioner suffered from severe depression, but nothing more than that. But that Dr. Farmer had other good information to give or something like that. What is that other good information? What's being referred to there?
The best I can understand, I think it's Dr. Fisher's testimony. I believe she testified at the motion for new trial hearing, but I think it's her testimony and her ultimate diagnosis that the petitioner suffered from bipolar disorder, which she said she based that diagnosis off of the petitioner's self-disclosure to the questions that she asked. She referenced the trial transcript and the proof at trial, but she never really pointed to much with any specificity what in the trial record would have shown that the petitioner was bipolar. And then she, again, sort of generally alluded to some of the symptoms that the petitioner displayed during his meetings with Dr. Farmer. That's what I think this court was referring to.
Sure. What about the objective basis? What the prejudice prong here? So your friend on the other side focuses, and for good and sufficient reason, most of the argument on the deficient performance aspect to it. Where is the evidence here that, objectively speaking, the defendant was under a threat of imminent death or serious bodily injury?
There is none.
Well, your friend on the other side says there's a shove. Defendant has the weapon drawn. Victim and his son keep approaching. So help me understand the context for that from your perspective.
So what we have to go back to is the petitioner was the one who first went to his car and got the gun. He then comes back, points it at the victim, and puts the muzzle of the gun either in his mouth or very close to his mouth. And at that point, the victim kind of puts up his hands and tries to back away. But the petitioner does not put the gun away, doesn't try and de-escalate the situation. He keeps the gun, he keeps it pointed at the victim. And what's really significant here is the victim is unarmed. The victim is unarmed, his family members are unarmed. There's just no evidence that anybody had a weapon that they were threatening to use against the petitioner, or really that they were being hostile. And I think this kind of comes down to sort of a battle of the witnesses too, because you had other witnesses, I believe it was the victim's sons, never testified that the victim or anybody else was advancing on the petitioner. This is all coming from the petitioner and his wife. The jury clearly rejected that testimony, as was its province. But if we boil this all down, it's the petitioner who gets a gun, brandishes it, points it in the victim's face, and the victim is unarmed and really not displaying any aggression towards the petitioner. And then we have the one shot that's fired, and then the petitioner's relatively calm after the shooting. He kind of puts the gun away and then waits for police to arrive. So there's just not enough here that would have convinced a jury that the threat of death or serious bodily injury was imminent and that that threat was objectively reasonable. And we have Dr. Fisher, too, who says multiple times during the post-conviction hearing that she couldn't testify to that objective belief prong, that it was a question for the jury. She said that repeatedly. And if the only thing that we have is one witness talking about sort of a gentle shove of the petitioner's wife, that just is not enough to create an objectively reasonable belief that there is a need to use force because there is a threat of death or serious bodily injury. And so counsel here, there just wasn't deficient performance, and there has not been any prejudice shown based on the investigation into the mental health issue. And there similarly has not been any deficient performance or prejudice shown regarding the strategic decision about witnesses to call at trial. Counsel investigated Mr. and Mrs. Hornsby and Mr. Plunk, and he made a strategic choice not to call any of those three witnesses. And this is a textbook example of one of those strategic decisions where this court will defer to trial counsel. Trial counsel is the one who has the boots on the ground and is talking to the witnesses and is responsible for sort of making these bigger picture decisions. And counsel made a reasonable decision here, especially with Mr. Plunk. He did testify that Mr. Plunk had a brain injury at the time of trial, said he didn't remember anything, and that he didn't want to participate. I believe counsel's words were he described Mr. Plunk as so squirrely that he didn't want him in the courtroom. And Mr. Plunk's testimony really would not have added much to the petitioner's case here.
Are there findings from the post-conviction court on this issue?
There are some that what we have is the court lays out its findings of fact, and it categorizes counsel's decision a couple times as either tactical or strategic. It doesn't have like a separate caption sort of identifying each and every claim as raised in the petition.
It looks like, it looks like the absence of this claim is conspicuous by its omission in the trial court's order. So without a conclusion from the post-conviction court on that fact, would Tate counsel that we remand on this issue?
It would not, Your Honor, because I think at the very end of the post-conviction court's order, there is enough here. There's enough of a finding where it says, counsel interviewed all potential witnesses and the petitioner has not established deficient performance or prejudice. I think that's enough where this court can tell what the post-conviction court sort of is identifying with the claim, and we do have a more than adequate enough record to allow this court to review the issue. So I think this is different than Tate, and this is not a situation where a remand is necessary. Unless there are any further questions, we would ask this court to affirm. Thank you.
All right, rebuttal?
Very briefly, I just want to kind of say, we're entering kind of a strange danger zone with this case. We have this really kind of weird situation where we have a body of law that describes what due diligence is and what the lack of due diligence is. Then we have a separate body of law that describes what deficient performance is and what deficient performance isn't. We might be in a situation here where the law makes it look like we can have lack of due diligence, but not deficient performance. That gap right there is a little bit of a danger zone. It's a danger zone. We can say that there's not due diligence, but it's not deficient. That's a little bit of an issue right there. And I would just encourage the court to be aware of that little bit of a danger zone moving forward and considering this case.
Let me ask you this. You're not alleging that trial counsel was ineffective for choosing a trial strategy of self-defense in defense of his wife, correct?
Correct. No, and that's what we would have gone with, I think.
Once he does that, how do you present, you say he was defective for not presenting the mental health evidence to the jury. How do you present that? Because you're trying to show the jury that he acted rationally and reasonably in defending himself and his wife. And then you're saying, well, he's not rational and not reasonable based on this expert testimony.
Right. So what we're doing is we're saying what he is doing is behaving as rationally as he can in that moment. But what we're looking at specifically is whether or not this was an unlawful act right here. So we have to look at his rational element, that rational element with all of this information in the context of it.
But isn't that a pure trial strategy issue? Whether to present that testimony about his mental health when you're making a self-defense presentation to the jury?
Not if you don't have the information. And trial counsel didn't have the information but made that choice anyway. The serious bipolar disorder with psychotic features, it's very different. And trial counsel did not have that information and chose not to argue that
Well,
point.
your friend on the other side, though, says that if trial counsel had taken the next logical step, and that was to interview Dr. Farmer, trial counsel still would not have had that information at that point. Are you saying the trial counsel had to interview Dr. Farmer and then go even further than that?
Well, I think probably that's what would have happened because Dr. Farmer's notes indicated possible bipolar disorder. At some point, he indicated that in his notes.
He ruled it out, though.
It possibly ruled it out. It looked like he did rule it out, but we've got the fact that the defendant is talking about taking medication and that medication is not working.
Severe depression medication.
Severe depression medication, but it's not working. There was a possible differential diagnosis that was not looked at, but now we know medication's not working. That tells us there's something going on that we need to look at further. Counsel should have looked at that to say what was going on there. That's absolutely something counsel should have done to figure all of that out. Furthermore, I was going to get to, defendant did discount psychiatrist and counsel spoke with family members and everything. Hey, he's a successful person. He's got a good social network, strong relationships. None of those are considerations for determining whether or not someone has a mental health disorder. Those aren't factors for that consideration.
The post-conviction cases do look at that, though, right? Because what we're trying to do is to figure out, I think in the post-conviction context, what information did trial counsel have that made the failure to investigate further unreasonable? And so the absence of information from the petitioner is considered, the absence of information from the family is considered, the absence of information from other people who know the defendant and the defendant's background. All of that is considered in the context of reasonable investigation strategies,
But
right?
what we're saying is that by not even talking with Dr. Farmer, he didn't investigate. By just not going there, that was a failure to investigate completely. And counsel has legal opinions, and those should matter, but his psychiatric opinions should not control the case. And failure to get a psychiatric input on this is where he went wrong.
Is ultimately the claim, and I'll let it go at this, is ultimately the claim that trial counsel should have investigated a diagnosis that was never indicated?
Trial counsel should not investigated a diagnosis that was never indicated, should have investigated the petitioner's mental health. That's how he should have been evaluated independently at that point and investigated.
Okay, fair enough.
At the very least, just investigated. I'll just end it, I have 16 seconds left here. Regarding the witnesses and the court's analysis of those witnesses that were called, if we're in a situation where we all have to say, hey, is this really adequate? Isn't it adequate? We've really got to go through here and find the pieces. If we're doing that, it's not adequate. I would just submit that to the court. Thank you very much.
Thank you, counsel. All right. You break? You break? Good. Okay. All right, thank you. Call the next case, please.
State of
Thought that was
Tennessee
a siren
versus
going off.
Jay Walker.